You turn it.
Good morning, Ms. Cloud. How are you today? Good morning, everyone.
Good morning, Judge.
Good morning, Judge.
Good morning. Ms. Champion, are we waiting for the jail to join us?
Yes, Judge, I'm gonna give them a call out to the jail to see what's going on.
Okay, thank you. Morning, courtroom two.
Good morning, Lana. How you doing?
I'm doing well. What about yourself?
Good. I'm about to let Mr. McLean in real quick.
Okay.
Okay, so whatever you're right, I'll give you a call. All right.
Good morning, Mr. McLean.
Good morning. Ready on Henderson? Yeah. Henderson, sitting in the room here. Position. Your Honor, this is gonna be Mr. Henderson. I don't have the position number right now. Position 10. Position 10?
Okay, so he's not in Cobb.
No, Judge.
What's the announcement?
Yes, sir. I spoke with Mr. Henderson and we're going to waive arraignment and be asked to be set on the jail jury calendar.
Okay, Mr. Henderson, your case is going to be returned to the division judge and you'll get notification of your next hearing date, sir. Good luck to you.
Thank you. And I'll submit all that paperwork, Your Honor.
Thank you, Mr. Dodes.
Good morning. Second and third roll. Sorry about that, Your Honor. I'm by myself today. I don't have my.
Okay. You're fine. Just let me know when you're ready.
Okay, we can start with, Mr. Tyrell Lee. Mr. Lee. 15. Position 15.
Okay. This is a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Lee. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you, Mr. Lee. Good morning, Ms. Dillingham.
Good morning, Judge Morrow. So this is a negotiated plea and the state has recommended in this case 12 months to serve, 26 days credit for time served, 13 days, balance probated with the stay away order from the address of the incident, which was 4995 Cascade Hills Circle.
McLean?
Nothing to add, Your Honor. We ask the court to accept this negotiated plea of guilty under those terms.
Mr. Lee, it's my understanding that in case 23 CR 0000248C, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Lee. Good luck to you, sir.
Thank you, sir. Thank you. Good to meet you. Next, we have position number 26, Mr. Nicholas Taylor.
This is also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Taylor. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, that's fine.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you. Ms. Dillingham?
Yes, Your Honor. The recommendation in this case was 12 months to serve, 24 days, credit for time served, 12 days, with the balance probated, no drugs, alcohol, or weapons, and a stay away order from the address in this case, which was the Ritz-Carlton at 181 Peachtree Street Northeast.
Is there a reason that the balance is probated?
Yes, Your Honor, due to the defendant's criminal history of 8 cycles of similar crimes.
Mr. McLean?
Your Honor, there's nothing to add. He asked the court to accept his plea of guilty negotiated.
Mr. Taylor, it's my understanding that in case 23 CR 0000247C, you wish to plead guilty to criminal trespass and theft of service. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No,
You've been represented by counsel. Are you satisfied with his representation?
that's fine.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Taylor. Good luck to you, sir.
Oh, Your Honor, I should add something. Due to his youth in the economy, I would like to ask the court to give him a financial break if possible on the probation fee.
So what I'm gonna do is I'm not gonna give him a break on the fee, but once he goes in and reports to probation, it's gonna become non-reporting after that. I don't want to utilize those services in that time. He'll still be on probation, but it'll be non-reporting probation once he reports the first time.
Thank you, Your Honor. I'll explain that further to him if he has any questions. Thank you.
Okay,
We're good. Next, Your Honor, we have position number 13. Mr. Jonathan Katz.
also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Katz. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me?
Yeah.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down. Thank you, Mr. Katz. Ms. Todd, good morning.
Good morning, Judge Morrow. In this case, the state's offer is 12 months to serve 30 days, credit for time served 15 days with the balance suspended, and a stay away from the 5 Points MARTA station.
Dodes?
Yes, Your Honor, that's our understanding of the offer, and we stipulate to the factual basis, venue, and ID for the purpose of this plea.
Mr. Katz, it's my understanding that in case 23 CR 0000190E, you wish to plead guilty to one misdemeanor offense, is that correct?
Yeah, I mean, okay.
Hold on, Mr. Katz. I just need a yes or no answer, okay? If you wanna discuss something, you need to discuss it with Mr. Dodes there, okay?
Okay,
All right, so you wish to plead guilty to that misdemeanor offense?
I guess,
Is that a yes?
yes,
Okay, are you under the influence of any drugs or alcohol this morning?
no,
You've been represented by counsel sitting beside you. Are you happy with his representation?
yeah,
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty, you're giving up your right to a trial by jury?
I guess so,
Okay, you don't want a jury trial, do you?
no,
Okay, has anybody forced you to plead guilty?
no,
Okay, I'll accept the your guilty plea, Mr. Katz. You know you can't go back to the 5 Points MARTA station, okay?
okay.
All right, good luck to you, Mr. Katz.
All right. Next, we have position number 17, Jason Pierce.
This is gonna be a non-negotiated plea.
It is, Your Honor. The issue, if I recall correctly, what position this is, the issue would be the 7 days of 7 extra days in jail proposed, had it been a negotiated plea.
Okay, who do we have on for Ms. Hudgens? Good morning.
Good morning.
Can you give me Mr. Pierce's history, please?
Yes, let me put up right here. So in regards to Mr. Pierce, he has the GCIC states he has a total of 6 cycles. He has a criminal trespass conviction in 2015. And he has a shoplift in 2014, but it doesn't give me the disposition, Your Honor. And it seems like the criminal history is cut off on here. Give me 1 second, Your Honor.
I'm gonna go on to Ms. Dillingham, and if there's anything further, I'll come back to you, Ms. Hudgens. Ms. Dillingham?
Yes, Your Honor, this incident occurred November 10th of 2022, where officers responded to a Panera Bread at 11715 Medlock Bridge Road. This defendant had previously been issued a trespass notice not to come on the premises November 2nd of 2022. And on this day, November 10th, he was asked to leave and would not leave until police came and had to escort him out. For that reason, the state is recommending 12 months to serve, 28 days, credit for time served, 7 days, balance suspended with a stay away order from that Panera at 11715 Medlock Bridge.
Thank you. Mr. McLean?
Yeah, and we had a discussion about how important it is to respect other people's property rights. I don't know if there were any problems in his life before that have caused him to be confused, but he seemed to have clarity yesterday. So we would simply ask the court to give him time served with the balance suspended and stay away order.
Does he have a place to live, Mr. McLean?
He's nodding his head yes, because it was balance suspended. I didn't fill out one of those contact sheets, so I'm afraid I confess personal ignorance. Would you tell the court where you're going to be living?
At my grandmother's house, sir,
Where's that?
in Duluth, Georgia.
In Duluth.
Okay,
Far from this Panera, good.
anything further, Ms. Hudgens?
Yes, he does have convictions for terroristic threats and acts, 2 counts. And that was in 2015. Was given 5 years to serve, 2 years, balance of 3 years probated. And then he also has another criminal trespass conviction in 2015 as well.
Thank you. Mr. Pierce, it's my understanding that in case 22 CR 007738A, you wish to plead guilty to criminal trespass. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced you to plead guilty?
No, Your Honor.
I'll accept the guilty plea, Mr. Pierce. Your sentence is going to be 12 months to serve 14 days, credit for time served 7 days, balance suspended, and stay away from the Panera on Medlock Bridge Road. If you go back to that Panera, Mr. Pierce, you will be arrested again. You'll be in violation of this order. You understand me?
Yes, Your Honor.
All right. Good luck to you, Mr. Pierce.
Thanks, Your Honor.
Good luck. Good to meet you.
Next, we got position 24 and 25, Mr. Sterling, Antoine Sterling.
I have that Mr. Sterling is waiving arraignment.
That's correct.
Okay, so the case will be returned to the division judge and he'll get notification of his next hearing date.
Very good. Thank you, Your Honor.
Okay?
Next, Your Honor, we have position 19 and 20, Mr. Keylando Potter.
This is a negotiated plea and a null pros.
Yes, Your Honor.
Good morning, Mr. Potter. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, Mr. Potter? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Ms. Dillingham?
Yes, Your Honor. So as this is a negotiated plea in agreement for that negotiation, the FTA was null prost. And then the recommendation for the criminal trespass case is 12 months to serve, 14 days, credit for time served 7 days, balance suspended, a stay away order from the address of the incident, which is 325 Andrew Young International Boulevard, no drugs, alcohol, or weapons, restitution of $487 to Georgia World Congress Center Authority, and probation can be terminated after the restitution is paid in full.
So you said balance suspended, but you really meant balance probated.
Yes, Your Honor, my apologies.
Okay, and do we have a specific person or place or address that he needs to pay to Georgia World Congress Center?
Yes, that is the 325 Andrew Young International Boulevard.
Okay. Mr. McLean?
Your Honor, he asked the court to accept his negotiated plea of guilty. I will ask the probation department after court to stay in touch with me on who the payee would be and the methodology. He receives a disability check, which has been turned off, as they say. And hopefully that will be turned back on soon. That will be the source of his income, with which he will pay the $487.
Okay. Mr. Potter, it's my understanding that in case 22 CR 005212J, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
No, sir.
I will accept the plea as negotiated. Mr. Potter, I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you pay the $487, then the probation is going to terminate, okay?
Okay.
So the sooner you get that paid, the sooner you're not going to be on probation. Good luck to you, sir.
Thank you.
Position 1 on the add-on calendar. Mr. Jones.
And what are we doing with Mr. Jones this morning?
This was from Tuesday, and I believe his relatives would be either in G33 or more likely on Zoom with us. That would be Ms. Jones. Ms. Jones. Oh, wait. Where is this? Oh, he must be on camera himself. The person-
He's on iPhone.
iPhone, which I'm trying to find the square.
All right, so I reset this case to until today's case to give counsel the opportunity to I believe get his mother here so that I could speak with her regarding her son, Mr. Jones. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Ms. Dillingham, can you remind me of the facts again, please?
Yes, Your Honor. This incident occurred August 21st of 2022, where officers responded to 1935 Allison Court Southwest after residents in that complex had called 911 informing they heard about 4 to 5 gunshots in the building, and they saw a male with the description that matched the defendant. When the police found the defendant, they did find a gun on his person, and they are still investigating whether or not that firearm was shot at that time.
Okay, and Mr. McLean, what have you spoken with the mother or the parents in the matter?
I've spoken with the mother, Your Honor. She is at home with 5 kids, except for the 15-year-old who would be at school. The rest are young enough where I think only a couple would be at school. So she has several children at home. And if there's some way I can call her and see why we're not on the video right now, that
Did you have the opportunity to speak with her and discuss this matter with her, Mr. McLean?
yes, I did talk with her on the phone yesterday.
Okay, is your client in school?
He is not in school right now, but he will be getting his GED, if I recall correctly. Is that correct? I'm sorry, I keep turning to you as a.
Can you unmute Joe Court's iPhone, please?
Yes.
Yes, you're getting your GED?
Yes, sir.
Have you started the process of getting your GED?
No, sir. I had got incarcerated, but I was in the process.
Where are you getting your GED from?
My mother is like a little online little courses, little classes that my mom post been purchasing me to get in the process of doing.
Okay, do you have a job?
No, sir. Not at the moment.
What else did the mother say, Mr. McLean?
Basically that she's going to help him and support him in any way she can. He always has a place to stay, and she believes he's turned a corner, but I was hoping to see her on Zoom today. She did say it was oftentimes very hard keeping up with the kids at home. So that's probably why she's not on Zoom right now.
Ms. Dillingham, what's the state's recommendation?
The state's recommendation is 12 months to serve 365 days due to the due to it being a gun case, Your Honor.
How long has he been in custody?
158 days, is it?
I am confirming that. Give me one moment. I beg the court's indulgence.
That's correct, 159 days, Your Honor.
Okay, thank you.
So the court probably sees our point that he's nearly at the 6-month mark at any rate.
All right.
Yeah, I'd use the word anyway, but it seems to minimize the thing, and he does take this seriously.
And if Your Honor is going to be inclined to release this defendant, the state would be requesting that he be placed on probation for the remainder of the time.
Okay, anything further?
If he's on probation, he would need a financial break if possible, due to his youth and trying to get a job. As he mentioned, he doesn't have one right. He wasn't leaving a job at the time of arrest.
But the state would also be requesting a curfew as a condition of that probation.
Okay. Anything further?
Nothing, Your Honor. Thank you.
Mr. Jones, it's my understanding that in case 22 CR 005603Y, you wish to plead guilty to possession of a pistol or revolver by a person under 18 years of age. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? You don't want a jury trial, do you?
Yes, Your Honor.
You understand you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced you to plead guilty?
No, Your Honor.
I'll accept your guilty plea, Mr. Jones. Mr. Jordan, you have something for me?
Oh, no, Judge, I was just logging on.
No, you just popped up there. I didn't know if you needed me for something.
Oh, I'm sorry, I didn't realize my camera was on.
You're fine. So I'm going to accept your guilty plea, Mr. Jones. The sentence of the court is going to be 12 months to serve, 318 days, credit for time served 159 days, balance probated. You are to live with your mother at her home address. You are to have a curfew from 9 p.m. To 6 a.m. You are to begin actively looking for a job. You are to provide probation on a weekly or bi-weekly basis with jobs that you've applied for, so that you can begin earning money and making money to put towards getting your GED. You are to enroll in some type of course to get your GED. You're to have no drugs, alcohol, or weapons while out on bond. I am going to waive the probation fees for you to help you get and stay on your feet, but you're going to have to be on probation for the entire term of the probation. If you violate this probation and you come back before me, you're going to have a problem. You understand me, Mr. Jones?
Yes, Your Honor.
Okay. You have any questions?
No, Your Honor.
All right. Good luck to you, Mr. Jones.
Same to you.
Position number 28, Mr. Walter.
And that's going to be a waiver.
Let me flip to that, Your Honor. Yes. Yes,
All
it is.
right. Yes, good morning, sir. Your case is going to be returned to the division judge and you'll get notification of your next hearing date, okay?
Okay, thank you.
All right. You're welcome. Have a good day, sir.
Next, Your Honor, we have position 7 and position 8, Mr. Charles Dinkin.
And this is going to be a negotiated plea.
Yes, Judge. I spoke with, Ms. Campbell, and it's gonna be time served, I believe.
Okay, and is that 8 days?
Yes, if we could, his booking number is not linked to this case on Odyssey, and so if I could just, Ms. Campbell confirmed if I could have someone with the court confirm that, upon taking this plea, he'll be released.
Yes, the FTA was for this case, so it should have been linked to this case. And I will note for the court that really he should have never even received an FTA, so there really never should have been a bench warrant because on the date that he FTA'd, he was actually in custody at the jail. So that's why the state is amenable to a time served offer on this case, as well as a no pros on the FTA case, because there should have never been an FTA.
Can you tell me how much time he's served?
He was booked on the FTA warrant 8 days ago. So it'd be 8 days just on the FTA warrant, but he's been in the jail, I believe,
39 days.
Okay, so what do you all want me to put on the paperwork? That's my only question.
It will have to be the 8 days, Your Honor.
Okay. Thank you, Mr. Walker. Good morning, Mr. Dinkins. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Anything further from counsel, Ms. Todd or Mr. Dodes regarding this before I take the plea?
I do just want to address the condition of that time served is a stay away from MARTA.
Okay. Do you want him to stay away from, does he have an active suspension?
I do believe he had one at the time, Your Honor. I can, if you'll indulge me for a moment, I can double check when that expired or if that has expired.
And Your Honor, this, with the age of this case, this offense being back in 2020, we would just ask for him to comply with any active MARTA suspensions instead of just a stay away.
The state would be amenable to that.
Okay. Anything further?
No, Judge. Excuse me.
Okay.
Sorry. We stipulate to the factual basis, venue, and ID for the purpose of this plea.
Mr. Dinkins, it's my understanding that in case 22 CR 006333D, you wish to plead guilty to 1 misdemeanor offense, 2 counts of certain acts on a bus, rail, or station that are prohibited, and possession and use of drug-related objects. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do.
Has anyone forced you to plead guilty?
No one has.
Okay. I'll accept the plea as negotiated, Mr. Dinkins. I'm gonna have you comply with any active MARTA suspension. So before you go back to MARTA, you're gonna have to make sure that there are no active suspensions. If there are no active suspensions, then you can go back there. If there are active suspensions, then you can't go back until that's resolved. You understand?
Yes.
Okay. Good luck to you, Mr. Dinkins.
So Judge, this is Melissa, can you give me the condition, the time served on this plea?
Yes. Good morning, Ms. Grace. It's 12 months to serve 8 days, credit for time served 8 days, balance suspended, and comply with all active MARTA suspensions. Okay?
Yes.
You're welcome. Good luck to you, Mr. Dinkins.
All right, thank you. You have a blessed.
You too.
Position number 4, Brown.
This is a waiver of arraignment and request for bond modification.
Yes, Your Honor.
What is the current bond?
It's a $10,000 surety.
How much?
$10,000 surety.
Who gave him that bond?
I believe Judge Law.
Okay. May I get his history, please?
Yes, Your Honor, I'm pulling it up right now. Mr. Dion Brown. In regards to Mr. Brown, he has 2 cycles on the GCIC, and that's for the current cases on the calendar. I don't have anything else on the GCIC, Your Honor.
Okay, so I only have one case, the battery family violence. Does he have another case?
Yes, he does.
Yeah.
Okay.
It's
What-
for
what-
battery family violence 11/3/2022, and then the battery family violence 1/12/2023, the arrest dates.
So he only has one of those on this calendar. Is that right, Ms. Todd?
Yes.
Okay, and so when was the arrest date or the offense date for the first battery family violence?
11/3. Oh, yeah, I'm sorry.
I'm so sorry, Ms. Hudgens. The arrest date for that case, Your Honor, was 11/3/2022.
11/3/22, and does he have a bond on that case?
He does, Your Honor. If you'll indulge me 1 second, I can pull that one up. We do know that bond, that case does concern the same victim as this case, and there was a no further contact ordered in that case.
Okay, and when you find the bond, let me know what that is for that case.
Yes, Your Honor. It was a $5,000 surety bond ordered by Judge Mincy.
Okay. And the facts of this case?
Yes, Your Honor. Officers were called to the Economy Hotel located at 9995 Old Dogwood Road. When they arrived, they spoke with the victim, Kevin Fountain, who stated that while he was on the phone with his cousin, he and the defendant got into a verbal altercation, which resulted in the defendant punching him in the face. When officers arrived, they were able to notice that as they spoke to him, that his eye continued to swell. As I stated, Your Honor, he does have that open case, which is concerning the same victim, only happened about 2 months before this case. And just to supplement his history, Your Honor, while he only has 2 counts on his GCIC, he does have an additional 5 charges out of Virginia and North Carolina. That is why Judge Law saw it fit to have the $10,000 surety bond. We ask that that remain in place.
Any circumstances changed, Mr. Duda, since that bond was granted?
Your Honor, my client has spent 15 days in jail. He's been unable to afford that bond, which is why we're asking to be heard.
Okay, go ahead. Anything further?
Yes, Your Honor. I don't believe my client is a risk of fleeing the state. He does have history outside of the state, but he spent the past year living in Atlanta, working and building up his career. He started a design firm, and he's planning on building that up. He has no plans on leaving. He's already looked into more temporary housing for him, and he's currently has 2 dogs that live with him that he cares for. And he's currently having a difficult time having a friend in the area care for those dogs before having to give them up. So he just does want to return and take care of those animals, which are like children to him, he wanted me to bring up. He's currently working at Publix in the deli department. They're holding that job. He's also started, as I said, his own clothing brand, HH Apparel, which he's ready to get back to. He studied software security at ITT Tech. He's not, Mr. Brown is clear that he can't have any further contact with the complaining witness, and he'd accept any additional conditions the court would impose to ensure the safety of all witnesses and that there is no further contact. As we heard from pretrial, he has no history of FTAs and VOPs. He's not I don't believe he's a risk to commit new crimes and not a threat to the community. We did hear about his prior incident with the same complaining witness back in November. Following that incident, it's my understanding that Mr. Brown and the complaining witness were living together, and Mr. Brown left, and that's why he's currently living at the Economy Lodge, close to his work, where he's been trying to find permanent housing while he lives in that temporary housing. But he followed the no further contact to the best of his ability, and my understanding was that the complaining witness tracked him down where the alleged confrontation took place. Mr. Brown, and I've been clear with him that if he's able to have his bond lowered and be released, he cannot have any further contact with the complaining witness and cannot tell him, it has to do with best to make sure that the complaining witness doesn't know where he is, so we can't come find him. Additionally, I saw no evidence that Mr. Brown was uncooperative during the incident. He spoke with Officer Powell at a separate location and returned to the incident location to speak with the victim. For these reasons, I would request a signature bond, but if the court is not agreeable to that, we'd ask for the lowest bond possible to allow Mr. Brown to be released and be a part of his defense.
Your
Go ahead,
Honor,
Mr.
if I may, just to correct something for the record, this defendant does have a history of two FTAs. One was in 2016 in Virginia and one was in 2019. And then again, I do just want to reiterate, this is the same victim 2 months later. So therefore, it is clear that he has an issue complying with the no further contact.
Okay. Mr. Dotis, I am going to, I'm not going to give him a signature bond. That's for certain. I will cut the bond in half to a $5,000 surety bond with all the other conditions that were on the previous bond. Okay. So $5,000 surety, all the same conditions, no drugs, alcohol, weapons, and if you'll get that to the court, I'll sign it.
Thank you, Judge. Will do.
Who do we have next?
Next, we have position 2 and position 3, Mr. Billings. Position 2 and position 3, Your Honor.
And this is will be a negotiated plea.
It will be, Your Honor.
Good morning, Mr. Billings. I'm Judge Eric Morrow. This is the state court expedited, the state all-purpose calendar that were conducted by video. Do you agree to have your case heard by video? Thank you. Can you raise your right hand for me? Do you swear? Okay. Who's Mr. Billings?
Courtroom 2.
Okay. All right. 3 South was raising his hand also, so I had to make sure that I had the right person. Mr. Billings, if you'll raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. Todd?
Thank you, Your Honor. The state's offer in this case is 12 months to serve, 68 days. Credit for time served 34 days with the balance suspended. No further contact with Kejuan Price, that's Kejuan Price, common spelling, and Kymir Pearson, that's Kymir Pearson, common spelling, and a stay away from the Exxon gas station located at 568 Chapel Road and ADET course.
Well, you said balance suspended, right?
I did, Your Honor, and I misspoke. That should be a balance probated. My apologies.
Okay. Yes, Mr. Dodes?
Yes, Your Honor. We do stipulate to the factual basis, venue, and ID. I will note that Mr. Billings has received 6 days of credit for the underlying charge and the 28 days for the FTA. So just to make sure he's not being held, could we reword it to serve 12 days, serve 6 days to make sure the FTA doesn't continue to hold him?
Ms. Todd?
It's been our understanding that that those days do count as the same, as long as that adds up to 34 days for the credit for time served.
Okay, I'll double check it then. Just want to make sure that no one gets lost out there.
Okay, so what do you want on the paperwork, Mr. Dodes? 68 days, credit for time served, 34 days?
I would prefer 12 and 6, but if we can't do that, then we'll go forward with. Either way, it's a time served offer.
Right, it's a time served offer, but we want to make sure that he doesn't.
I would, yeah, if everyone's okay with it, I would just do 12 days, serve 6 days.
That's fine, Your Honor.
Okay, very good. Thank you.
Thank you.
Anything further, Mr. Dodes?
No, Judge, we stipulated the factual basis venue and ID if I didn't say that earlier. Thank you.
Okay, Mr. Billings, it's my understanding that in case 22 CR 005223D, you wish to plead guilty to possession and use of drug-related objects and giving false information to a law enforcement officer. Is that correct?
Yeah.
Is that yes?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Billings. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Okay.
All right, good luck to you, Mr. Billings.
Position 27, Mr. Wet, position 16, Mr. Matthews.
Okay, so is Mr. Matthews, is that in jail court? iPhone? Okay. Good morning, sir. And this is your case, Ms. McLeod? Good morning.
It is, Your Honor.
And what are we doing with Mr. Matthews this morning?
We're hearing a motion for modification of his bond, Your Honor.
Does he need to be arraigned?
He was already arraigned, Your Honor.
Okay, and what is the current bond and who set it?
The current bond was set by Judge Williams, I believe, and it is for a $5,000 good bond, Your Honor.
And what's the breakdown?
It was, I believe it was $4,000 for battery, family violence, and $1,000 for cruelty to children.
Okay. What's his history, Ms. Hudgens?
Well, there's some other information which I would like the court to hear, Your Honor.
Okay, I want to get his history first, then I'll come back to you, Ms. McLeod, for you to give me anything further, okay?
Yes, Your Honor.
If that's okay with you.
That's fine.
Ms. Hudgens?
This is for Mr. Wagner, correct, Your Honor?
No, Mr. Matthews, position number 16.
Oh, I'm sorry.
You're fine.
16. Okay, I'm pulling it up right now. Number 16, okay. His history includes Matthews. Oh, David Matthews. Okay. In regards to Mr. Matthews, he has a total of 18 cycles. He has a burglary from 2018. I mean, 2008, I'm sorry. He has, I'm gonna go backwards. That's why he's here now. He does have probation violations. He has at least 2 from what we see. I'm working my way up, Your Honor. Give me 1 second. He has a conviction for theft by receiving stolen property in 2015 in Fulton County out of the Superior Court, a felony. He also has another theft by taking a reckless conduct in 2015. He has, that was amended to. And he has some other arrests on here, Your Honor, but it looks like most of them were null pros or not presented.
Okay.
He has a theft by receiving stolen property, 2 counts in 2011.
And Your Honor, if I may, Ms. McLeod mentioned earlier, it was a $5,000 bond. It was actually an $8,000 split bond, $5,000 surety for the battery, $500 for the cruelty to children 3rd degree, and $2,500 surety for the disruption of the 911 call.
Okay.
He does have out-of-state history in Florida as well, Your Honor.
And what are the facts, Ms. Dillingham?
Yes, Your Honor. This incident occurred May 22nd, 2022 at 5475 Oakley Industrial Boulevard, which is the victim, Brandy Gillespie's residence. The victim had asked the defendant about his whereabouts, and in response, unprovoked, he became hostile and aggressive. Defendant grabbed Ms. Gillespie, choked her until she could not breathe, punched her in the right eye with a closed fist, and broke and threw furniture all around the house. This was done in front of their 2-year-old daughter, who was in the room at the time and could have been harmed by the thrown items. When officers arrived, they observed the injuries that Ms. Gillespie had to her face. And as well, I believe it was lacerations to her arms, Your Honor. So for that reason, along with defendant's 18 cycles of arrest, the state has recommended 12 months to serve 120 days, credit for time served 48 days, balance probated. FBIP, absolutely no further contact with Brandy Gillespie. A stay away order from her address, 5475 Oakley Industrial Boulevard. Third-party contact for their children. And additionally, Your Honor, as I mentioned, there was one of the charges was interruption of a 911 call. I believe it was their neighbor who tried to call, and the defendant knocked the phone out of her hand so that she was unable to do so.
Ms. McLeod?
Yes, Your Honor. The facts as alleged by the prosecution are simply incorrect. Ms. Gillespie herself was here at Mr. Matthews' first appearance, hearing and absolutely disputed most of those facts, including the knocking the phone out of anybody's hand or interference with any 911 call. She also disputed the fact that their child was present when any of this happened. She testified that what happened was that he wanted his clothes to leave, and she was trying to prevent him from getting his clothes. I've actually had the opportunity to watch the body cam footage and all that when the police officers came to the house. I watched all of that, and even on that, she did not testify to some of what the prosecution is saying. My client was not there at the time. He had gotten in his car and left. This incident allegedly happened sometime in May of last year. After the incident, Ms. Gillespie and my client continued to cohabit, live together, and raise their child until he was recently arrested. I filed for a speedy trial for Mr. Matthews. Mr. Matthews was scheduled for trial on January 17. I showed up to the state court of Fulton County ready to proceed in the jury trial, and I was casually informed by the state that, oh, there was a glitch in the system and they didn't bring him over. Your Honor, he would have been out of jail as far as this charge is concerned because the state knew they did not have any witnesses, and because of that, I don't know how they managed to engineer this, but my client was not there for his trial. I was there. Judge Baxter was there. We were all ready to go forward, and that was the excuse. There was a glitch in the system. He's not here. Based on that, Your Honor, my client should not be still sitting in jail because there was a glitch in the system. Incidentally, I was called by a supervisor from the jail who informed me that that was absolutely untrue and that his name was simply not placed on the pull list for jail that day. Based on that, Your Honor, I would ask the court to just give him a signature bond so he can get out of jail on this case. Because I believe, I have been informed that the state has been threatening the so-called witness to lock her up. And because they knew that she wasn't planning to show up for this trial, they simply engineered this. That's what it appears to me.
Did you, give me a moment. Did you ask Judge Baxter for modification of the bond at the time when they did not allegedly bring him over?
I did not, Your Honor.
Okay.
And Your Honor, I would note for the record that the hearing that Ms. McLeod is speaking to, I was the ASG that initially handled that hearing. And Ms. McLeod is correct that the complaining witness did show up via Zoom and she did recant. However, Your Honor, is fully aware of the fact that we oftentimes have complaining witnesses in domestic violence cases recanting because they are still in a relationship with the defendant. So the state is going to note for the court that that does not mean that we're not able to secure her presence for trial. A lot of what Ms. McLeod said was speculation, and it was also hearsay. We don't have the complaining witness here today at this bond hearing to testify as to whether or not she wants to proceed with the charges. What we do have before the court today is a motion for bond reduction, and the state's position is that the bond as currently set is appropriate until we can get the case to trial. For whatever reason, it did not proceed on the trial date, but the state has not no-prossed the case. And as far as the state is concerned, we're still going to go forward with these charges.
Ms. Campbell,
Yes,
were
Your
you
Honor.
there? Were you there on the trial date?
No, but I was present for the initial, the calendar, the C calendar, where bond was initially addressed.
I want to speak to the trial date, okay?
Okay, no, I wasn't present for the trial date.
Let me ask my questions, please. Who was the solicitor that was present for the trial date?
I would have to get that information, but
Why did he not go to trial or on that date?
I'll find out, Your Honor. But
Okay, that's what I need to speak. That's what I need for you to speak to. If he was scheduled for trial, and if what Ms. McLeod is telling me is true, that he was not brought over to engage in his trial, and that Judge Baxter was there and ready to go forward with that trial, then that's a problem. So I'm going to give
him not brought over wouldn't be the state, the Solicitor General's office. If she's saying he wasn't brought over, is she saying that okay, so what I'm saying to Your Honor is that would be by no fault of the Solicitor General's office that he wasn't produced for trial.
Is it his fault that he wasn't produced for trial? Should I punish him for not being?
No, Your
produced?
Honor, but the state's question at this time is what would be the cure on today's court date, because we can't have a trial today.
Okay, well, the cure is that I'm going to let him out of custody on a signature bond. That would be, I'm not going to keep a man in jail who was supposed to have a trial on this matter, a speedy trial on this matter, and through no fault of his own was not produced when apparently everyone was supposed to be there.
Yes, Your Honor.
Ms. McLeod is representing as an officer of the court that she was ready to proceed to trial on this matter. There must have been a trial calendar regarding this matter if she showed up. And it's not Mr. Matthews' fault that he wasn't produced. I mean, this could have been, handled one way or another by now. And now he's just sitting in jail through no fault of his own, given that he can't make this bond.
Your Honor, if I could just have the court's brief indulgence to reach out to the Solicitor General that was actually handling the trial calendar that day before Your Honor makes a ruling, I would really appreciate that.
Okay, that's fine, Ms. Campbell. I'll give you till the end of the calendar. So we'll come back to Mr. Matthews, okay?
Thank you.
You're welcome. Who do we have next? We'll be back to you, Mr. Matthews.
Position number 11, Johnson.
And this is going to be a negotiated plea?
Your Honor.
Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning.
Good morning. Is that a yes?
Yes.
Okay, can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down, Mr. Johnson. Thank you. Ms. Todd?
Yes, Your Honor. The state's offer in this case is 12 months to serve 30 days, credit for time served 15 days. Excuse me. With the balance probated, no further contact with D. Ebony Terry, that's DE''EBONY, Terry common spelling, and a stay away from 906 Ralph David Abernathy Boulevard.
All right. Mr. Dodes?
Yes, Your Honor. I don't see balance probated on this offer, so I would ask for balance suspended. I don't see any conditions.
Ms. Todd?
I have that on my sheet, Your Honor. However, if that wasn't properly communicated, I do believe we should be okay with the balance suspended in this case, as there are no additional reporting conditions.
Okay, anything further, Mr. Dedes?
Thank you, Ms. Todd. No, Your Honor, we stipulate to the factual basis, venue, and ID for the purpose of the plea.
All right, Mr. Johnson, it's my understanding that you wish to plead guilty in case 23 CR 0000223F, to simple battery, is that correct?
That's correct.
Are you under the influence of any drugs or alcohol at the present time?
No, I'm not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Johnson. Good luck to you, sir.
Thank you.
You're welcome. Who do we have next?
Back to courtroom 2, Your Honor. We have position number 1, Mr. Banks.
Okay, and this is also your case, Ms. McLeod? Are you with me, Ms. McLeod?
So I'm trying to unmute.
Okay, what are we doing with Mr. Banks today? Ms. McLeod?
Yes, Your Honor. I haven't had a chance to talk with my client yet, Your Honor, so I'm not sure exactly what's going to happen in this case.
Okay, can we get Ms. McLeod to speak with Mr. Banks? Do you have the number to the courtroom, Ms. McLeod?
No, Your Honor.
Ms. McLeod, you can call 22392. I'll send them over now.
Okay, thank you.
Can we go to position number 23, Mr. Michael Shannon?
And this is a negotiated plea?
Yes, Your Honor, it is.
Okay. Good morning, Mr. Shannon. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Oh, yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. Dillingham?
Yes, Your Honor. The state's recommendation is 12 months to serve, 28 days, credit for time served, 14 days. Balance probated due to the defendant's 25 cycle arrest history. A stay away order from the address of the incident, which was 720 Donald Lee Hollowell Parkway. No drugs, alcohol, or weapons.
Does he have a history of theft?
Yes, Your Honor. Yes, Your Honor. A history of theft, entering automobiles with intent to commit theft, willful obstruction of law enforcement, criminal trespass, battery, as well as possession of marijuana.
What was the theft in this case?
The theft in this case was 2 12-packs of Budweiser and 1 12-pack of Bud Light from the BP gas station at that address.
Mr. McLean?
Your Honor, despite the cycles, he is an industrious person. He has worked at car washes, which is not easy work. He has worked at Cookout. He has worked at food places and various labor places. While he will have an income, he will get a job as soon as he can get out, Your Honor. He'll have an income. He would ask the court to give him a financial break if possible on the probation fees. And so we ask the court to accept his negotiated plea.
Okay, Mr. Shannon, it's my understanding that in case 23 CR 0000242F, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, I do, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, I'm not, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am satisfied with his representation.
Okay, you understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I'm well aware of that, Your Honor.
Has anybody forced you to plead guilty?
No, sir.
Okay, I'm going to accept the plea as negotiated, Mr. Shannon. I'm not gonna waive the fees for you, but what I'm gonna do is that once you go down to probation to report, you're gonna have to report one time, and then it's gonna go to a non-reporting status. So you're still gonna be on probation, but you're not gonna have to report. But if you violate any of these conditions, that probation is gonna be revoked. You understand?
Yes, Your Honor. Do I have any, way of knowing how to get to the probation officer?
Yes, your counsel's gonna let you know, okay? You'll get the information.
Okay.
All right.
Thank you, Your Honor.
You're welcome. Good luck to you, Mr. Shannon.
Okay, thank you, Your Honor.
You're welcome.
Position 27, Mr. Wagner.
I haven't had a chance to meet Mr. Wagner yet, Your Honor. That was to be announced if I could hold that for later.
Okay, where is Mr. Wagner is the jail court's iPhone?
Yes.
Okay, all right. Do we have a way of getting Mr. McLean to speak with him?
I've spoken to his family on the phone, but I haven't spoken to him.
Well, you need to speak with him, so we need to get that.
If they could bring him down, or I could go to that floor, either way.
We can call the number. If we have a extra phone you can use.
Duffy, call 22391, the 91 number.
All right.
All right.
Okay, thank you. Anyone else that we can take?
Can we hold off on that phone call so we can do position number 22? Yeah, I got it.
Okay. And this is gonna be a negotiated plea?
Yes, Your Honor.
Good morning, Mr. Roberts. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Ms. Dillingham?
Yes, Your Honor, the state's recommendation in this case is time served, 12 months to serve 30 days, credit for time served, 15 days, balance suspended, and a stay away order from all MARTA locations.
Mr. McLean?
He asked the court to accept his negotiated plea of guilty, Your Honor. We did discuss this, and of course, key to success in the future is not confusing all MARTA versus 5 points MARTA, and he understands the difference.
Okay. Mr. Roberts, is my understanding that in case 23 CR 0000189E, you wish to plead guilty to one misdemeanor offense and criminal trespass, is that correct?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Roberts. You know you can't go back to MARTA, right? Mr. Roberts?
Okay, that's fine.
Okay, all right. Good luck to you, sir.
Thank you.
I've been trying to get my other case. They will not give it to me. They're in the hospital.
Okay, where is Mr. Posey? Is that at 3 South?
Right here.
3 South.
Oh, hi, Mr. Posey. Good
God
afternoon.
bless you. How you doing?
Good
Judge
morning. I'm doing fine, Mr. Posey. I hope you are too. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, yes, sir.
Okay. Can you raise your right hand for me, Mr. Posey?
Yes, sir.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Who's presenting for the state?
My apologies, Your Honor.
Okay, you're fine.
This is a negotiated plea. The state's recommendation is 12 months to serve, 30 days, credit for time served, 15 days, balance suspended, and a stay away order from all MARTA, no drugs, alcohol, or weapons.
Mr. McLean?
Nothing to add, Your Honor. He asked the court to accept that.
Mr. Posey, it's my understanding that in case 23 CR 0000187Y, you wish to plead guilty to criminal trespass and certain acts prohibited on a bus rail station. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Posey. You know you can't go back to MARTA, right?
By how long?
For the entire time that you're on probation, or would have been for the 12 months, okay?
12 months? Okay, okay.
All right, good luck to you, sir.
So I got time served?
Yes, if you don't have anything else holding you, that you'll get out as soon as the jail can process you out, okay?
Okay,
All right,
Thank
good luck to you, Mr. Posey. You're welcome.
thank you.
I'm talking on the phone. All right. Your Honor, McLean is about to talk to Mr. Wagner on the phone.
Okay, is there anyone else that we can take, or are we gonna be in recess?
I guess it will be recess. Miss McLeod is still talking to her client.
Okay, all right, you all let me know when you're ready.
Okay.
Thank you.
Your Honor?
Yes.
In Mr. Wagner's case, he does have another case with a different lawyer in our office on the felony level. And he has a large bond on that he cannot make. So his freedom for me making a bond argument today would be moot. So I would like to ask to reset this case so we can get beyond the glitch of me being able to see him in person at the visitation booth, discuss it with him and report to you next week.
Okay, and has he been arraigned yet?
Not yet, Your Honor, but we could do that next week if necessary.
Okay, or you can file a waiver if you choose. So you want me to reset him until for a week from today?
That's fine. And by then, I'm sure that other lawyer will have gotten my voicemail and called me back.
Okay, and that is that the 2nd of February?
February 2nd, next week.
Yeah. Yeah. Okay.
Okay, all right, so we'll reset for February 2nd. We'll see you back next week, Mr. Wagner.
Thank you.
And I have that we're just holding on both of Ms. McLeod's cases.
That's correct, Your Honor.
Let's see, while we're holding for that, Ms. Grace.
Yes, sir.
You want to go ahead and go over the calendar since we only have 2 more positions left that are both Ms. McLeod's?
Okay, I have more than 2.
What else do you have?
Your Honor, I know I'm also holding on position 5.
5, yes.
Okay, so I've got 1 and 5.
I do believe we also have not addressed position 6 or 9.
I have 6 as a waiver. And I have 9 as a waiver also.
Yes.
Yeah, 9 waiving presence and arraignments. 6, we do need to waive arraignments.
Okay, so if you'll get those filed.
Will do.
So, yes. So Judge, you want to wait or you want to?
Okay, so we're waiting on position number 1. That's Ms. McLeod's. Position number 5, that is Mr. Dodez. Who was the position that the state was looking into for me? That we were going to come back. That's
16 Matthews.
And we're waiting on number 16, which is also Ms. McLeod's case.
I do have that information, Your Honor, requested at the appropriate time.
Okay, I believe that Ms. McLeod is speaking with someone right now, so let's wait till she gets back on the line. Thank you, Ms. Campbell.
Okay, well, we'll just wait until she comes back.
Oh, there she goes. All right, Ms. McLeod. So position number 1, Mr. Banks, what are we doing? You've had an opportunity to speak with him, is that right? You're on mute.
I'm sorry, Your Honor. I have spoken with him. He really is interested in taking a plea, but I did not know what the state's offer was, and I sent a few messages asking and did not get back any feedback. So he has indicated that he would be interested in a non-negotiated plea.
Okay, can we put on the record, Ms. Todd, what the offer is?
Yes, Your Honor. The state's offer in this case is 12 months to serve 30 days, credit for time served 15 days with the balance probated, SDET, and a stay away from the College Park MARTIR station.
You need to talk with him regarding that offer, Ms. McLeod?
Yes, Your Honor. And what exactly is SDET? That acronym is not registering with me.
A sexual deviance evaluation and treatment.
Okay. Okay. Thank you.
Do you need to call him back?
I do, Your Honor.
Okay, so if you'll go ahead and get that done. Well, before you go, Ms. McLeod, just so we can, do we have Mr. Matthews? Is that Mr. Matthews in courtroom 2 right now?
That's position 1, Your Honor, Mr. Banks.
Okay. This is Mr. Banks. Where is Mr. Matthews? Position 16.
I believe he's where the jail court iPhone.
Yeah, that's 4 South, Your Honor. You have a officer that's roving. They just
Okay.
Yes.
All right, so I was trying to deal with Mr. Matthews, but Ms. McLeod, go ahead and speak with
I will, Your Honor.
oh, here he goes. Mr. Banks? I'm sorry, Mr. Matthews?
Yes, sir.
Okay, very good. I understand, Ms. McLeod, that we have an update from Ms. Campbell. Go ahead, Ms. Campbell.
Yes, Your Honor. I did speak with the ASG that was assigned to handle the trial on that date that Ms. McLeod referred to. She did advise me that the state was prepared to move forward with trial that day, and that, again, as Ms. McLeod advised, the defendant was not produced by the jail. So the comment about the state making reference to a glitch and that's why the state wasn't moving forward, that was inaccurate. As I was told by the ASG, we have had contact with the victim even up until trial. More specifically, we made 6 different attempts to go to her residence and serve her. She was evading service. However, the victim, the complaining witness, did call us back and tell us the reason why she wasn't at home on the 6 days that we tried to serve her for trial was because she was in Wisconsin taking care of a sick family member. And so we have reviewed the evidence in the case, the body worn camera, and we do believe that this defendant poses a danger to this victim. And so, as I stated before, the state is going to be moving forward with trial once we get another trial date. And the state was prepared to go forward with trial on the trial date, the speedy trial date that Ms. McLeod referred to. So the state's request at this time is that the bond remain as set and that he not be let out on a signature bond because he is a danger to the victim based on the facts of this case, based on his history, as well as based on the fact that we do believe that this defendant may have been intimidating the complaining witness to not comply with service and show up for trial. That's what the ASG that was handling the trial on the trial date told me, is that she has grave and serious concerns about witness intimidation with this particular victim. More specifically, she stated that the same day the victim filed an affidavit with the court saying that she didn't want to go forward with the charges, and said affidavit was not notarized. That was the same day that Ms. McLeod filed her speedy trial demand. So from all of that context, the state believes that there may be witness intimidation involved with this case, and we have even greater concerns about the victim's safety for that reason.
Was your witness present and ready to proceed to trial on the day of trial?
No, she was not present, Your Honor, but there was other evidence that the state was going to be introducing, as I mentioned. We can go forward even if we don't have the actual physical presence of the complaining witness. There was a responding officer, there was body worn camera. And so, as I stated before, we tried to serve her 6 different times. She's evading service, but she has been in contact with our office. And she indicated that the reason why she wasn't home was because she was in Wisconsin taking care of a sick family member. But we were going to be going forward with trial that day. So as far as Ms. McLeod saying that everybody was ready to go forward, but the state, and that it was the state's fault and there was a glitch and he wasn't produced for trial, that's inaccurate.
Whose whose division is this in?
Judge Morrison, and the ASG that handled the trial that was going to be going to trial that day was ASG Aaliyah Harmon.
Okay, so given that, Ms. McLeod, given that this was in the division Judge Morrison's courtroom, I'm going to have you go back to Judge Morrison to review this matter. If you want to file a motion in that regard and argue it before.
I filed a motion, Your Honor. What the state is saying is totally inaccurate.
Okay, I'm gonna give her the opportunity to address that, given that this was in her division at that time. It might have been a little easier to address this if you had addressed the issue of bond with Judge Baxter at that time when he wasn't present. Because he would have had more information regarding this than I do today. So I'm going to have you go back to Judge Morrison to argue your motion for modification, okay? All right, Mr. Matthews, good luck to you.
I believe
Yes,
the complaining witness may be on, Your Honor. I thought I saw her on earlier.
I am here.
Okay, and who are you, ma'am?
I am Brandy Gillespie. I am the victim, and the state just lied. That is not what I told her. The witness is not intimidating me.
Okay.
I didn't say that you said that there was witness intimidation. I said the state has concerns about witness intimidation.
He's not intimidating me. You shouldn't have any concerns. I have spoken with you guys. He's
Well,
not
Your Honor, my statement
intimidating
at this
me.
time would be that if Your Honor has made a ruling about sending it back to the division.
I did not know that we had someone should have informed me that we had the alleged victim on the line. So
Yes.
if we have somebody on the line that needs to speak prior to me making a ruling in the future, please let me know. I did not know that Ms. Gillespie was present today. Ms. Gillespie, have you had any contact whatsoever with Mr. Matthew? Oh, first of all, raise your right hand, Ms. Gillespie. The other right hand. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Have you had any contact whatsoever with Mr. Matthews?
No, he's been in jail. No.
Regardless
That
of
is-
whether he's been, have you had any phone
No.
contact with him, any social media contact with him?
No.
Any physical contact with him?
No.
Any contact whatsoever with him?
No.
Okay. And what did you want to tell the court regarding being intimidated by him?
I'm not being intimidated by him. We have a 2-year-old child. The child was not present when we were having the disagreement in the parking lot. That is true. I have been traveling a lot, but I told her that I didn't want to go forward with the case, that he's not intimidating me, that I didn't want to proceed. She constantly says that they have to serve me, that I have to come to court. She thinks that he's going to attack me, that he's going to do something to me. He is not threatening me. He's not intimidating me in any type of way. I'm saying this of my own free will, that the argument didn't go like that with the body cam. It was the neighbor that called the police.
Okay. Any questions, Ms. Campbell?
Yes, Your Honor. Ms. Gillespie, isn't it true that when the police arrived on scene that day, you gave them a statement?
Yes, I did.
And isn't it true that in that statement that you told the police that this defendant struck you in your face?
I don't remember.
Okay.
Telling them that.
Do you recall that the officer that responded was wearing a body worn camera when he responded to the incident that day?
No, I don't recall that.
Okay, so you're not aware that your statement was recorded by a body worn camera?
No.
You're not aware of that? You're not, okay, and you're not aware of the fact that your injuries, including your scratches and your bruising, was recorded by the body worn camera that day?
No.
Okay, and you're also not aware that the condition of your home that day, with it being torn up and everything strewn about, that was recorded on body worn camera that day? You're not aware of
And
that?
I advised you that I broke the mirror, that I did that. I have spoken to you and told you that that was my damages. I knocked over the mirror.
I
So it's my
haven't had
mirror.
a conversation with you, but you're
Okay.
advising the court right now that when the police arrived, there was a broken mirror at the time?
Yes, I broke the mirror.
Okay, and that was during the course of this violent incident with this defendant, correct?
There was no violent incident.
So how did the mirror get broken?
I knocked it over with going out the room. It was on the
Okay.
floor.
Nothing further from the state at this time, Your Honor.
I do have a question for Ms. Gillespie.
Okay.
Ms. Gillespie, since the incident happened, I believe it was the 5th of May or sometime in May of last year, were you and Mr. Matthews living together until he was arrested?
Yes.
Nothing further.
Okay. And once he was arrested, he hasn't been living there since that time?
That is correct. But we were in contact after the incident, but we haven't been in contact after he got arrested.
Okay.
He was picking the baby up and dropping the baby off from school. He's also my dad caregiver. My dad has dementia, so he helps with my dad a lot.
And does your father live at the 5475 Oakley Industrial Boulevard address?
Yes.
And has he been back to that address since his arrest?
No, sir, he has not.
All right, anything further from council?
Nothing further, Your Honor.
I would just ask briefly, Ms. Gillespie, if you know, isn't it true that your father told the police that this defendant has shown violent tendencies towards you in the past and that he's afraid for your safety? Isn't that true?
No, not to my knowledge. And how can you ask a dementia patient and a patient that has Parkinson's to make a statement?
Okay, thank you.
All right. Thank you. Ms. McLeod, based on the totality of the circumstances in this matter, I am going to convert this to a signature bond with all the previous conditions on that bond. One of those conditions being that there's to be no further contact whatsoever with Ms. Gillespie and a stay away from that incident address. He can have, if it's on the original, he can have third-party contact with his children, but he cannot have any contact with Ms. Gillespie. Ms. Gillespie, I need for you to activate your camera again. Until this matter is over, Ms. Gillespie, neither Mr. Matthews is not to have any contact with you whatsoever. He is not to come by the Oakley Industrial Boulevard address. If he does, he's going to be in violation of this bond. You will have to resolve this before he's going to be able to return there or to have any contact with you. No contact means no contact whatsoever. If he is to have visitation with his children, he's going to have to arrange that through a third party. You understand me? You're on mute, ma'am.
Sorry, we don't currently have a third party. He does.
Okay, he's not going to be able to visit. You're going to have to have a third party. Okay.
Okay.
So that's no ifs, ands, or buts about it. Okay. He's going to be in violation if he has any contact with you. You understand me?
Okay. Yes.
Okay. So if he's going to see his children, he's going to have somebody else arrange that for him. Ms. McLeod, your client has his hand up.
Mr. Matthews, please call me after this and I will speak to you. Do you have my phone number? If not, ask the officer at the jail and call me. Don't say anything.
Okay, so make that modification and get it to me. I'll look it over, Ms. McLeod, and if it's appropriate, I'll get it signed, okay?
Thank you, Your Honor.
All right, now I believe that you need to, thank you. Have a good day, ma'am.
Judge, can you give me the breakdown?
I don't know it right. Well, the breakdown is going to be the same breakdown. It's just going to be a conversion
to a signature bond.
To a signature bond, yes.
Okay.
With all the conditions that's on the original bond, Ms. Grace.
Thank you. Okay.
You're welcome. So Ms. McLeod, you're going to need to speak to your client now. Is that right?
Yes, Your Honor. I would like to speak with them.
Okay, so if you can call
525.
And then have we gotten Mr. Brown ready? Position 5?
We're still looking for him, Your Honor.
Okay.
All right. So what are we gonna do with Mr. Banks?
Oh, she's calling right now.
Yes, I'm gonna call the jail.
Okay.
All right, so we have 2 left. Can we go over the calendar now? Ms. Grace, while we're waiting?
Okay.
All right.
Okay, we're holding on position 1. Position 2 was a plea. Position 3 was a plea. Position 4, reset jail jury with a modified bond coming in. Position 5, we're holding on.
It's very, I don't mean to interrupt, but I believe position 3 should be no pros.
No pros, yeah, it's a plea. We
Okay,
said.
make sure.
Okay, position 6, gonna be reset jail jury. Position 7 was a plea. Position 8 was a plea.
That's gonna be non-prost also. Hello?
Oh, there it is. Judge, are you there?
For some reason, I'm clicking in and out.
Yes, we
So
all
I'm-
did.
Oh, okay. I didn't know if it was just me or not. Okay. Where are we?
Position 13, I'll go back, I think, was a plea. Position 14 showed loan out, so I need a reset date for whomever case that is.
Let's reset it a week.
Okay. That'll be 2-2. Is that correct?
Yes.
Position 15 was a plea. Position 16, reset further notice. Position 17 was a plea. Position 18, 19, and 20 were pleas, with 20 being a null pros. Position 21, reset further notice, defendant was released. Position 22, 23 were pleas. Position 24, 25, reset jail jury. Position 26 was a plea. Position 27, reset 2-2 SAP. Position 28, reset jail jury. Position 29 and loaned out.
So we're gonna reset those for next week, 2-2. Let's see, I know some people are with me. I don't know. I think we're having glitch problems. Can you hear me, Ms. Hudgens?
I can hear you.
Oh, okay. All
I can
right.
hear you as well.
Okay.
I have a question. For
Yes.
Mr. Matthews, you gave him a signature bond. That wasn't through pretrial. Was it through pretrial or?
Say it again.
You gave did you give Mr. Matthews a signature bond?
Yes, it's gonna be through the jail.
Okay, thank you.
Okay, and Ms. McLeod, have you had the
Yes,
opportunity to
I
speak?
had the opportunity to speak with Mr. Banks, and he is going to accept the state's offer.
Okay, and does he have the paperwork to get that filled out?
I don't know if it hasn't been sent to me. I don't know if it's been sent over to the jail, but it can be sent over, Your Honor. I am prepared to sign it. I had spoken to him prior to this, before when we were talking about taking a non-negotiated plea. I had gone over his rights with that time.
Okay, so, but he's still gonna have to complete the paperwork before we get. And were we able to find Mr. Brown?
Your Honor, we're still looking for Mr. Brown.
All right, so you all tell me what you want to do. I'm willing to hold on Mr. Brown and hold on Banks. We have to get that paperwork filled out.
What are we doing with Mr. Banks?
He's gonna take a plea, it's my understanding. So we need to send you all the paperwork.
Okay, Your Honor, we'll work on the paperwork in the interim. I just called Mr. Howard to see if he's available to do the competency calendar. If you would like to.
Oh, okay. I was not aware of a competency calendar today. Can someone send me the competency calendar, please?
Absolutely.
And can you send it to, do you have my work address, Mr. Walker?
Let me turn my camera. The county email or your?
Yeah, personal work. I'm not on the county email at the present time.
I believe I've emailed you before.
Okay, I think so. If you can send it to me there.
Okay.
I appreciate it.
Doing that right now.
Okay, so we will be in recess until, and then we'll go into the competency calendar and give them an opportunity to round up, to get position 1 completed and to round up Mr. Brown, position 5.
And I believe there was a DV bench warrant, one case on that calendar as well.
Yes. If, Your Honor, for position 5, this isn't holding Mr. Brown, so if we could just reset it out a week.
Okay, we'll reset it to 2-2.
Thank you, Judge. And McLean, I think, is ready to go on the DV when we're ready for it. Correct.
Is the client on? Oh, is that Mr. Hanan?
Yes, sir.
Oh, and is this, I don't have that calendar. Who's presenting this for the state, Ms. Campbell?
Yes, Your Honor.
And is it Mr. Hanan that's on that calendar?
That's correct. Hernan Hernandez.
Hernandez.
Okay, Hernandez. Good morning, Mr. Hernandez. I'm Judge Eric Morrow.
Good morning.
Let's see. Are you ready, Mr. McLean?
Yes, Your Honor. He just did it. Yes, Your Honor.
Okay, Ms. Campbell?
Yes, Your Honor. So the state's request of this court is that the bench warrant remain in place. He actually was given a $3,500 surety bond back on July 9th of 2022. He was actually ordered to stay away from the address of 5555 Roswell Road and have no further contact with the complaining witness, Reina Pineda. He posted bond, it looks like 9 days later on July 18th of 2022. And he had a plea and arraignment date before Judge Besson on December 15th, 2022. And he did FTA on that date and his bond was forfeited and a bench warrant was issued for his arrest. It looks like today's calendar notice, when he signed it, he actually listed the address, the 5555 Roswell Road address as his listed address of record. And that is the same address that he was ordered to stay away from as a condition of his bond. That's now.
Mr. Hernandez,
no more.
Mr. Hernandez, I'll give you the opportunity to speak through your counsel, but we don't interrupt people, okay?
Okay, sorry.
I apologize, Ms. Campbell. Go ahead.
No problem, Your Honor. And just briefly, the facts are that on the date of September 23rd of 2019, this defendant and the complaining witness did get into a verbal altercation that turned physical, and the defendant grabbed the victim by her hair, and he actually scratched her on her chest as well, leaving visible red marks. He did flee the location after physically attacking her, which is why we're here today, because he wasn't arrested on scene. There was a warrant issued, and here we are almost 3 or 4 years later.
Okay, thank you. Mr. McLean?
Your Honor, my understanding is that the failure to appear occurred simply because of an address apartment number across the hall. There's something like, I don't know the exact number, but for example, a letter and a number. And oftentimes a typo, or what I refer to as a handwritten typo, sometimes people write down the wrong number. Now, as to the 555, what was it? 5555 Roswell Road. He can stay away from any place that he's ordered to, but he does need to make sure, of course, that mail gets to him. I've also explained to him when I talked to him yesterday on the phone that besides relying upon mail, he can certainly check with the clerk in person at the public computer at their desk, which they provide for the convenience of the public. You go every 2 weeks, you can't miss your court date, because that way you're not relying upon somebody telling you on the phone. And he intends not to miss any court dates. He says this was inadvertent. It was not purposeful.
Okay, can someone give me, and let's see, Mr. Jordan or Ms. Grace, can you all give me where the notice was sent, what address that notice was sent to? Or Ms. Campbell, can somebody give me where the notice was sent?
There's the notice was sent to 555 Roswell Road, apartment J27.
Apartment what? Apartment what?
J7. I'm sorry. Apartment
J7?
J7.
Okay.
Now I'm not sure if he lives in that apartment complex, but the bond order also says stay away from the 555 address.
So that's a problem, Mr. McLean.
Yes, now the across the hall from J7 is J what? J5?
Yes, J5.
J5 is across the hall. So if he can't stay even in the same apartment complex, that's fine. If he has to move, he'll move. But he can.
No, it's not whether he has to move or not. He shouldn't be there. I mean, he's in violation if he is at apartment J7. So it's irrelevant whether he can move. Right?
I understood it to be an address hiccup rather than the actual staying there hiccup. Mr. Hernandez, if he could speak to that, Your Honor.
If you would allow him, if you want him to, put your hand down, Mr. Hernandez. What do you want to say about that?
That's fine.
Sir, can I speak?
Yes, go ahead, please.
Okay. Yeah, the address right there, that's my address, but my son's mom, she don't live in that address no more at all. Like, she moved to another city.
First, let's find out it's J5 or J7 is correct.
J5, right here's my address.
Okay. And the alleged victim is not in town.
No, she lives in Georgia, but she lives in Doraville.
Okay. Perhaps I should ask the court to modify the stay away order.
Your Honor, I would object to that only because this is the information that the defendant is providing to the court. I mean, we don't have any sworn affidavits. We don't, all we have is what he's telling us. And so he was ordered to stay away from that address. And so until we can have the complaining witness herself confirm that she has moved to a different address, the state would not be comfortable at all with agreeing to.
I agree with you, Ms. Campbell. I'm not going to modify anything until you all have an opportunity to speak with the alleged victim. What I will do, Mr. McLean, is that I will reset this until my calendar on Tuesday. I'm not sure if I'm going to be here on Thursday, but I know that I'm going to be on the SAP calendar on Tuesday. So you've got until next Tuesday to verify that. Campbell, you think so? Can you have your victim advocate get in touch with the alleged victim, Ms. Campbell, to see if she's still at that location or not for the court?
Yes, Your Honor. And if I may just clarify, Mr. Hernandez, are you saying that you live at apartment J5? That is your current address?
Yeah, that's my aunt's house. Yeah, I live there.
J5 or 7? Is it J5?
J5.
Was the J7 involved at all in the mail?
The original court notice was sent to apartment J7.
What was that?
Okay, the original court notice went to J7 and he's in J5 and that's why he didn't get his mail. But the other matter of who lives where, we can settle by the 31st, which is 5 days from today. Okay.
Okay. So does that give you enough time, Ms. Campbell, to get in touch with for your victim advocate to get in touch with the alleged victim?
Yes, Your Honor. Thank you.
Okay, so we're not going to do anything with this case until next Tuesday.
Right. And
Your Honor,
my argument is, I'm not saying that he, had the exact conditions correct on the thing, but as a practical matter, as a practical matter, he's not in contact with her apparently. And that he's in good faith is what I'm saying.
Your Honor.
Well, technically he wasn't supposed to be there. So if he was supposed to be there, you should have done it the proper way and done a bond modification to allow him to stay there instead of him just on his own going back there without in violation of the order. So
point taken, will be discussed further.
Okay, I will give you all till next Tuesday to rectify this.
Thank you.
Mr. Hernandez, what else do you need?
I could
like, I don't get it, I don't get in touch with her, but
No, you cannot get in touch with her.
Yeah.
my mom, she
Oh,
talks to her.
We'll talk on the phone further, Mr.
Okay.
She could call her, she could tell her to call
I
her.
don't, let your lawyer do the lawyering, Mr.
Okay,
Hernandez.
okay, okay,
Thank you.
All
Thank you
right.
so much.
We'll see you next Tuesday.
okay, thank you.
Okay, so courtroom 2, I still need the paperwork on Mr. Banks. Do we have everybody ready to go to the competency calendar or not?
Your Honor, IT was here working on my computer. I'm looking at my email right now.
Okay,
Judge Morrow,
yes,
Attorney Mondelli say he's in court in another location, so he's gonna log on when he's
Okay.
available. He has positions 1 and 2 on the competency calendar.
okay. Thank you. All right, so we're gonna be in recess until we're ready for the competency calendar.
Can we?
Your Honor, I didn't receive the plea paperwork, if you're there. I don't know who's supposed to be sending it.
It's plea and arraignment.
Hey, Your Honor, I was still waiting for that plea paperwork. I don't know if Mr. Walker sent it to me.
Mr. Walker, are you with us?
I'm here, Your Honor.
Were you able to get the paperwork to courtroom 2?
Walker, send it to me, Norris.
I thought Ms. McLeod was sending it, but I'm sending it to you.
Yeah, please.
Thank you.
Is SAP over, y'all? I'm so sorry.
No, we're not quite over yet. We still have one plea that we take. We still have the competency calendar at 11 o'clock.
Okay, well, just making sure. Thank you.
Okay, you're welcome. All right, are we ready for the competency calendar?
Yes, Judge.
Okay, so if we can all be put into the breakout room. And Ms. McLeod, I'll be back with you as soon as we're done with the calendar, and hopefully the plea will be ready at that time.
Your Honor, I also have a client on the competency calendar.
Oh, okay, very good.
And the jail one.
Can I be placed? Sorry.
Yes, Ms. Campbell, happy to place you in there also. So,
You want to talk?
who all needs to go in? Let's get into a breakout room with Ms. Campbell, Ms. McLeod, courtroom 2. Mr. Walker. Who else needs to be in the breakout room?
It's courtroom
Mr. Howard and Miss Kasha.
Right, we in courtroom 2, so.
Okay.
That is a baby. Oh, you know what, Dad?
Ms. Burr? No, you're on mute. Your case is gonna be sent back to the division. It doesn't appear that that warrant was ever issued on your case. So I need to reach out to the litigation manager and they'll reset your case and schedule it for another court date. You're on mute. I can't hear you.
Hello.
Yes, I can hear you now.
Yes, sir. I just want to let you know that I had did my Plug Defender application yesterday, and I received an email saying that my application was determination because I made too much income. So they told me I was going to have to hire a private plug attorney.
Okay. So you'll have time. So I just need to reach out to Judge Dixon's litigation manager so she can pull your file folder and add it back to the calendar. So that warrant never got issued for some reason. So it's been like over a year and the warrant still hasn't been issued on the case.
Yes, sir. And I believe I have one because I know 2021 when they
Oh no,
sent my
you're okay. Yeah, so it'll all be settled in Judge Dixon's courtroom. But right now we don't have a warrant on your case at all.
Okay.
You'll get a notice in the mail for your next court date.
Yes, sir.
All right, so you're free to go.
Thank you, sir. You have a great
You're
day.
welcome. You too.
Thank you. Bye-bye. He said, "Baby."
Dudley,
Yes,
they still in a breakout.
this thing keep freezing up, Blunt.
So what I did was their entire computer, then I started all over.
So what?
I unplugged the entire computer, then I started all over again yesterday.
Okay, well, it's working right now, but I'm gonna see how long it's gonna take. All right.
Okay, let's see. Are we ready for the plea for Mr. Banks?
I'm ready, Your Honor. I'll be taking the plea.
Okay. Thank you, Ms. Campbell. And let's wait for Ms. Cloud to get with us. Are you ready, Ms. McLeod?
I am, Your Honor.
Okay. And this is Mr. Banks. Can you hear me all right, Mr. Banks?
Yes, sir.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. Campbell.
Yes, Your Honor. It's my understanding that this is a negotiated plea. The state's recommendation is going to be 12 months to serve 30 days. Credit for the time he's already served 15 days. The balance is to be probated, and the conditions are that he is to do the SDET course.
Okay, Ms. McLeod.
Yes, Your Honor, that is my understanding of the terms of the plea.
And was there a stay away from the College Park MARTA station also?
That's correct, Your Honor. Yes.
Okay, all right. Mr. Banks, it's my understanding that in case 23 CR 0000219C, you wish to plead guilty to 3 misdemeanor offenses. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this
No, sir.
morning? You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I will accept the plea as negotiated, Mr. Banks. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, sir.
And you understand, Mr. Banks, you can't go back to that College Park MARTA station, right?
I understand, sir.
All right, good luck to you, Mr. Banks.
All right.
Thank you, Your Honor.
Okay, I think that completes the 9 o'clock state all-purpose calendar. Mr. Jordan, are you with me? As far as, we had one that was left on the competency calendar with Mr. Was it Moretti?
Mondelli?
Yeah, Mondelli, and
Yes.
given that we are complete now and he's not with us, we're gonna reset that case 1 week.
Okay, thanks, Judge. I'll send him an email, let him know.
Okay, all right.
What about Della Rosa? Are you guys taking a plea from him?
Della Rosa. Do we have a Della Rosa?
Yes, that's the one Mr. Howard was speaking on.
All right, he's not on the calendar, but Mr. Howard would like to take a plea.
Oh, you want to take that plea today, Mr. Howard? You're on mute.
Yes, Judge, we were wanting to do that today.
Has he completed the paperwork?
Yes, and I've emailed it to Ms. Grace.
Okay,
Yes, I have it.
Did the jail bring him?
He's on the video. That's him. Yeah.
all right, can you hear me, Mr. Della Rosa? Mr. Della Rosa, can you hear me?
Yeah.
All right, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. Mr. Walker, can you recite the case number and the charge, please?
Yes, Your Honor.
Awesome.
Second. Mr. De La Rosa's case number is 22 CR 006666F, and he is charged with criminal trespass, I believe. The state's recommendation is 12 months to serve, 116 days, credit for time served, 116 days, balance suspended, with a stay away condition of 57 Forsyth Street, Northwest.
Judge, we do stipulate to a factual basis venue ID in this case. We would ask the court to accept that plea as negotiated.
Okay. Mr. Dela Rosa, it's my understanding that in case 22 CR 006666F, you wish to plead guilty to criminal trespass. Is that correct? Is that a yes? Are you under the influence of any drugs or alcohol this morning? That's a no. You've been represented by Mr. Howard. Are you happy with his services? You understand that you have a right to a trial by jury and that by pleading guilty, you're giving up your right to a trial by jury. Do you understand that?
Yes.
Has anybody forced you to plead guilty? Say it again. Has anybody forced you?
No.
Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Dela Rosa.
Thank you.
Okay, anything further this morning?
Nothing further, Judge, from.
All right. Is there someone at 4 North that we missed?
I'm not sure. He's on a composite calendar, position 11 through 13. Mr.
Okay. Yes, we don't need to see him this morning. Thank you.
Okay. All right.
All right.
Judge, position on the regular calendar, 29 and 30 loaned out to Alpharetta. We're gonna reset them to the second.
Yes.
Okay, thank you.
All right, and Mr. Howard, you're gonna call G33?
Yes, let me
Okay.
get on and do that now. Thank you.
All right, y'all have a good rest of your day. See you
too,
next
thank
time.
Thank you, Your Honor.
Be safe.
Have a good one.
You too.